Welcome again. In this video, we're going to talk about the second part of analysis when we think about distinctiveness of a trademark, and that is secondary meaning. Now, why do we want to talk about this? Why is this important? So, trademarks are designed to protect symbols, names that are connected or associated with certain goods or services. Trademarks are intended to distinguish products or services in a market. In that sense, the USPTO and the authorities in charge of protecting trademarks' rights will protect only those trademarks that actually have that ability to distinguish products or services in the market and will not protect terms or forms sometimes that actually are necessary for that market to operate appropriately. So, when it comes to trademarks, those trademarks or words that are necessary for our market to actually work for participants to describe or explain goods or services, well, those are out of the scope of protection of trademark law. However, those that are unique and distinctive and have that capacity to actually differentiate products or services in the market, those are entitled to protection. And we know that distinctivity is actually a spectrum. We have generic terms which cannot be protected, but we have descriptive terms which may be protected if they have what is called acquired distinctiveness. And how you actually demonstrate acquired distinctiveness? Well, you will show that that term has a secondary meaning in the mind of consumer and when that trademark is applied to the goods specific or services at issue. So let's look how this actually works. Okay, so when we think about secondary meaning, we think about a meaning that is different from the ordinary meaning of words. And one of the most iconic cases in trademark law is the case of Kellogg's versus National Biscuit Company. Here, the term at issue was shred wheat. And the court in this case also spoke about trademark rights and patent rights. And why is this? So, National Biscuit Company was a company that was the holder of a patent right. And it was the patent right to produce in certain way biscuits made of wheat. And for many years, they had the monopoly, let's say, to produce these biscuits. And as a result of that, it was the main producer of these biscuits, and it had been known for many years. However, that patent expired. And as you may know, once a patent expires, the public in general is free to apply that method or to use that patent product in the market. And what happened is that Kellogg Company had been in the market for many years, and they also produced cereal. Once that patent of National Biscuit was expired, Kellogg's Company and other companies as well started to produce this wheat biscuit, which was made of a pillow shape and had certain characteristics. It had been boiled and then it had been shredded to look as we can see on the screen. Kellogg's was offering this product in the market using the words shred wheat. So the court explained that sometimes words that are part of a patent, for instance, and there's a producer, someone who has the monopoly of those words, well, once that patent is finished, the monopoly ends for the production of that product, but also to use those terms as necessary by the market. And considering this, the court says that to establish by application of the doctrine of secondary meaning, here as regarding shred wheat, the claimant must show that the primary significance of the term in the mind of the consuming public is not the product, but the producer. So National Biscuit had to demonstrate that by using the word shred wheat, the relevant consumer identify this biscuit to be produced by them, National Biscuit, which at the end, National Biscuit was not able to actually demonstrate. Additionally, the court concluded that the term shred wheat was descriptive in this market because it was describing the goods that were, of course, similar to a generic word that is cereal for breakfast, but shred wheat was specifically referring to this kind of cereal that could be produced by many others in addition to Kellogg's. So the court considered the claim of the plaintiff, in this case National Biscuit, which was to enjoin an alleged unfair competition by the manufacture and use of the words shred wheat by Kellogg's. And the court basically said that in this case, those words were not entitled to total protection, that it's true that for many years, National Biscuit had been the producer, but the market needed to use those words. And as a result of that, shred wheat was not a descriptive term which enough significance as to be able, the plaintiff, to prevent others from using those words. Those are actually words that were necessary for the market to compete and to explain what the product was. Now, the court also explained that the test was not whether the public at large understood about a term, but actually whether the relevant public understood when thinking about this term. And again, the court insisted it is the primary significance in the mind of the consumer that a term actually makes reference to a producer and not to a product. Okay. The court also noted, and I have here a picture of corn flakes. I'm not sure if that's the box that that was used by Kellogg's in 1938, but it's an illustration that shows something, and is that the court mentioned that even if those words were they had a secondary meaning, even if that was the case and National Biscuit was entitled to protection, it is also relevant to consider that every time Kellogg's promoted its product, it was also accompanied by a word, Kellogg's, in a stylish form with certain color, that it was more prominent, the use of that word in that specific style, the red letters, than the word shred wheat. So basically, the court highlighted that Kellogg had also made efforts to avoid confusing the public and to distinguish its product from that of National Biscuit. The court also discussed, like, okay, so we have to prove secondary meaning when it comes to a descriptive term, but how do we actually prove that? And the court highlighted that we don't have to prove that the term has a secondary meaning in all the public, but certain relevant public, and that you demonstrate that maybe by the use of certain style or graphic elements, maybe the packaging position of that mark in the products. You may also consider who is the consumer, the age of the consumer, preferences, whether this is a sophisticated consumer or not, the channels of communication, the media, advertising materials, sales amount, and of course, surveys are some of the strongest evidence. So the mark may be used in certain contexts and may be perceived by the consumer in certain manner, but how we use the trademark, it will depend whether it is the term is performing a trademark function as a source identifier, or maybe those words are only describing the goods, and in that sense, there is no secondary meaning. Now, why is this case important? And this is something I want to highlight because the court emphasized how do you prove secondary meaning and what's the relevant test, or what you need to focus when you want to prove that a descriptive term has actually acquired distinctiveness. So as you saw in the case of Kellogg's, the court will consider different aspects when looking if a term is descriptive, and if it's descriptive, whether it has acquired secondary meaning. The process again is first, look what kind of trademark do we have. Second, let's look whether there is a specific or dictionary term that is more relevant. And third, let's look on the primary significance of that term in the specific context, market, and as applied to the goods or services that are relevant. Now, after that, there's been many other cases discussing whether a trademark is descriptive or not, whether it has acquired secondary significance, whether it has acquired distinctiveness. There is no black and white rule regarding this term. Additionally, it's important to understand that sometimes the federal courts have been split regarding what factors they think are more relevant, and we have now a more recent cases that have also deal with this idea of secondary meaning and the protection of terms that are descriptive. One of those is Booking.com, and what happened in Booking.com is that Booking.com tried and was applying to register the trademark Booking.com, a generic word as booking because it describes a service, which is being able to book a hotel or a trip with the top level domain .com. Now, the USPTO rejected the registration and said the term is generic and we cannot give this company the monopoly of that term because the industry in general will be affected. And this will also affect consumers who want to look for services, book services with other companies. The US court rejected those arguments and explained that in general, let's look at this term. Would the average consumer actually look for a booking.com? No, probably not. The consumer wants to book a flight and they will use probably the word book to look for services that are similar. But the consumer is not going to use booking.com as a noun to book that as a specific service. Now, additionally, the court said here we also must consider that we can say that any term in any circumstances is entitled to protection. We cannot create a per se rule. It's important to use our analysis to study every context and every market separately. It's a fact-intensive analysis. And in this case, the court observed especially that Booking.com offer a great amount of evidence regarding consumer surveys and how the consumer actually perceived the trademark Booking.com in the market and as applied associated with that specific service. And that was, in this case, what convinced the court that Booking.com was entitled to protection. But the court was also clear about something, and is that this is not a per se rule in favor of registrability and is not a per se rule against registrability. Basically, every case is different and doesn't mean that you can register flowers.com, pictures.com, etc. It will depend in each case of the evidence offered by the party who wants to defend its trademark, because that party is the one who has the burden of proving that a descriptive term has acquired secondary meaning. So I hope this video is going to start to give you a more clear idea of what is secondary meaning and how you actually demonstrate secondary meaning. Please review your materials, complete your quizzes, and if you have any questions, please leave it on the comments.